Strydom. I'm an attorney practicing as a director at PH Attorneys in the Bloemfontein branch. I'm the head of the family law department and I specialize in family law. I want to speak to you today about a very recent and very pivotal judgment that was granted in the Constitutional Court of South Africa on the 10th of October. So that's roughly 2-3 weeks ago. The judgment is significant in the sense that it affects people married out of community of property without the exclusion of the accrual system. In layman's terms, if you're married on the basis that when you get divorced, mine is mine and yours is yours, as the previous disposition stood. This judgment, however, has changed that situation a little bit. How does it change it is the first question, and why is it relevant? Most probably the second. Now, firstly, what is important to note is that the Constitutional Court found that Section 7.3 of the Divorce Act, which deals with divorces where parties were married out of community of property with the exclusion of the accrual system, and prior to 1984, when the Matrimonial Property Act came into existence, are entitled to ask the court and claim at a divorce for a redistribution of assets from the other party. Again, to explain it simply, to share, in essence, in the other party's estate. Now, what changed is that the court said that that section, specifically in that portion of the section, to say that the claim that the spouse may have only affects people married before 1984, is inconsistent with the Constitution, and that that section should be changed and amended by the legislature to also now include marriages after 1984. That means that the old saying of mine is mine and yours is yours is no longer that straightforward. It applies immediately in this judgment, despite the fact that the legislature must still amend the Act. What it does do is the judgment says that immediately as from the date of the judgment, should a matter go before a court and a claim be instituted for Section 7.3, it can already now be heard on the basis that even if you were married after 1984, with the exclusion of the accrual system, you're entitled to claim for a redistribution. Now, many people think, and we hear and we say, oh, now I'm entitled to share in the estate. Again, it's not that simple. This is not a right, not an automatic right. It's still the onus of the party coming to court to say that they believe it would be just and equitable to share in the assets or to ask for a redistribution, that will in fact be just and equitable. So you have to prove certain things to the court. You cannot just show up and expect that you're going to get a share of the estate. Now, there are factors that the court must consider when you look at Section 7.3. And what a party who claims must prove to the court is firstly that there was a contribution from that party to the growth of the other party's estate, whether that contribution is direct or indirect. For instance, if you are, let's say, a wife, and why I say that is because it's also pivotal to the judgment, is you got married out of community of property without the accrual system. You, for instance, had a job at the time when you were married. Shortly after that, left your employment by agreement, started looking after the children that were born of the marriage. Worked in a company, for instance, owned by the husband. Saved expenses in the sense that there might not have been a need for a nanny. There might not have been a need for a domestic worker. Those factors play a large role in determining whether a party actually made a contribution to the growth of the estate. And what the court found in this judgment is to say that because women, historically, it's starting to change now, but it's still the case in many instances, are unfortunately the parties in marriages that are financially less better off, in the sense that husbands, as we also know historically, are the bread earners, and wife, as a rule, looks after the kids, are indirectly discriminated against on the basis of gender, because of the fact that you could only claim for a redistribution before 1984. Now, nothing changed after 1984 pertaining to that part of the judgment. Only thing that makes a difference is after 1984, you could actually get married with the inclusion of the accrual system, which then gives you a right in the accrual with your own terms included in the accrual to share in the accrual of the estate. Now, what this judgment means is that despite the fact that when you got married, you decided mine is mine and yours is yours, even if you had the right to claim for it or enter into a marriage with the accrual, you are now entitled to say, despite all of that, considering the factors that were present in the duration of the marriage and the factors that are present at the divorce, I'm still entitled, if the court finds that it's just and equitable, to share in some of the estate of the other party because I made contributions to it. Now, something that came up in my mind immediately when firstly the Pretoria High Court, I think it was 2 years ago, made the order that the section should be declared unconstitutional, and the matter was then referred to the Constitutional Court, is what is the purpose then of entering into an anti-nuptial agreement to exclude the accrual system if you are now entitled to go to court and prove, which you still must, that you can share. This is a factor, in my view, that the court will take very seriously into consideration when determining the factors that the court must look at to decide whether it is just and equitable to share or a redistribution to be allocated, and also as to what allocation must be done. How much? 10%, 25%, 50% of the estate? And what will come up, in my opinion, very strongly is, why did you then enter into a marriage, excluding the accrual system? And what happened after that to put you in a position now that you feel that you are entitled to a redistribution? So, a lot of exciting litigation lies in front of us. A lot of exciting legal development lies in front of us. It's a bit uncertain, one must say, but I think it's a very good situation that we find ourselves in the sense that the law is evolving and also considering how our society at this stage looks in broad in South Africa. So, if you are a party married in the way that we just stated, with the exclusion of the accrual system, hopefully you don't need to get divorced, but as we know, things happen. And if that does happen, keep in mind the fact that you may claim for a redistribution, but again, as I say, it's not simply for the taking. You have to prove your case, and the court must decide whether such a distribution will be just and equitable. Just maybe on a side note, the fact that the court decided that the section is inconsistent with the Constitution because it discriminates towards gender, mostly in the form of women, this doesn't preclude men to institute the same claim. Should the man fall on the other side of the fence, in the sense that you have a wife who has built up an estate, and you as a husband, which we see many times today, and it happens quite often now, becomes the homemaker. So it's fair game for both parties. And yes, as I've said, I think it's going to be exciting to see how this expands. Please also just keep an eye open, for those of you listening, for further or further changes that might follow and developments as the case law progresses, and we promise that we will keep you updated as that happens. Thanks for your time. Thanks for listening. Keep well.